Baptiste and the Investment Managers Limited.
Good morning.
Good morning, everyone. May it please the court, I'm David Rajkumar. I'm here on behalf of the appellant. I'm instructed by Alyssa Khan, that's behind me. I'm also assisted today by Mr. Eve Nicholson, who's a member of the English Bar.
Yes.
For the respondent, counsel is Colin Kangaloo. He's instructed by Ms. Danielle Neves.
Yes.
And they are both from the firm of Fitzwilliam Stone. Let me see if I miss it out. Fitzwilliam Stone, Furnace, Smith and Moore.
Yes. Well, Mr. Rajkumar, we have read the papers and the very helpful cases, the statement of facts, the written decision of the trial judge, so we're very fully familiar with the background to the case. We conceive at this stage, certainly, that this is largely a factual dispute, and you will be aware of the constraints on the board in reviewing concurrent findings of fact. So we'd like you to concentrate on that, and we would expect, without, of course, abbreviating your presentation unduly, we would expect a reasonably economical presentation of the case.
I'm guided, my lords. I would say that, of course, there is one very important fact, and that is the fact of whether or not a direction was given. But I don't believe that the case rests solely upon...
do you accept that if a direction was given, then the debt was discharged and the shares were deliverable?
No, my lords.
Even if a direction was given?
Even if a direction was given.
I see. And what, in summary, is the basis for that submission?
In summary, the basis for that submission is that there would have been no consideration for that alleged purported variation.
Why do you need consideration? Leaving aside whether consideration existed in that situation. If you owe me money and I say you can discharge your debt to me by paying my friend Jim, that's a discharge, isn't it?
Well, that would be a discharge if Jim were somebody to whom I owed a debt and I was merely instructing...
No, you owe the debt to me. And I say, would you please discharge your debt to me by paying my friend here, who I owe a similar sum to. Now, that is a discharge by consent, isn't it?
Oh, but you said that who I owe a similar sum to. And
it doesn't matter. It could be simply I want to make a present to him.
Well, yes, okay. So for whatever reason, if I wish that you paid Jim instead of me, most likely it was because I probably owe Jim the money. That would be an assignment. That would be an assignment of a debt that you owe to me, and I assign it to some other.
It wouldn't necessarily.
But maybe not necessarily.
It wouldn't be an assignment because Jim couldn't sue you directly, which he could if he was an assignee. It's just a question, as between you and me, whether your compliance with my direction by paying him is a discharge of your obligation to me. He doesn't need to be party to the arrangement at all.
I suppose I don't want to conflate too many concepts, because what I'm thinking about, of course, in the circumstances of this case, we would have to, in making the determination as to whether they could possibly have been a direction, and looking at the evidence, which Lord Kerr's asked me.
Now there you're going back to facts.
I'm going back to facts.
And back to the point that my Lord in the chair raised with you about the concurrent findings problem.
I suppose I'm going back to facts because the answer to your question will be, I think, the answer to most questions in law, which will be, well, it depends. It depends. I don't want to make a concession that simply giving a direction and that direction being complied with would necessarily amount to a discharge of the debt. But it is difficult for me right now to think of why it would not be. I suppose my focus is going to be in illustrating that in this case that simply didn't happen, and I'll try to explain. Try to explain why the evidence is very clear that it didn't happen. But I'd have to think a little bit more about your question, Lord Sumption.
Well, I think you have said that you would find it difficult to argue against the proposition that if you comply with the direction to discharge the debt in a certain fashion, that's an end of the matter. And for my own part, I think you're right to accept that. I don't necessarily characterize it as a concession, but let's proceed on the basis that there isn't scope for a great deal of debate on that particular proposition, and let us hear you on the reasons that you say that the evidence compelled a different conclusion, keeping in mind the difficulties about overturning concurrent findings of fact.
Now, the place that I would like to start, before I delve into the evidence of the direction, but it's very much related,
Yes.
is the question as to, did the High Court, I want to look at the High Court decision in a little bit of detail.
Yes.
Because you'd have seen from my case that my submission is that the High Court did not make a primary finding of direction. He made a secondary finding of direction in support of a primary finding that the agreement had always been to pay the company. And I wanted to deal a little bit about why I say that. I think that makes a difference to the whole complexion of the case, because I will lead you to the point of showing that the Court of Appeal, thinking that they were endorsing the High Court's decision, were endorsing something else that the High Court did not decide. So the first thing I would ask then is that we go to paragraphs 26 and 27 of the High Court decision.
Can you give us the...
In the hard bundle, that is page 475, volume 1, and the electronic bundle, I think that's MS 484.
Yes, which paragraphs again, please?
So the top two paragraphs,
37 and 38.
Paragraphs 26 and 27.
26 and 27. I think that's a little early. That's 482, yeah. Yes?
I'll just read them very quickly. It is clear, and I find on a balance of probabilities, that the monies referred to in the agreement were to be paid as directed by the defendants into the company in the light of the difficulties it had been facing. Paragraph 27 is, the claimant's involvement was in respect of an investment in the company. It was not a buyout of the defendant's personal interest. So he's very clear there that he's finding that the agreement was for an investment in the company. That is to say, that the agreement always was to do what the respondent had done. That's a completely different thing, entirely from saying that the agreement was as was written, and then was subsequently varied by direction. So this is why I say that the direction, he uses the word direction, but it was merely, to this judge, confirmatory of his finding that the agreement always was to pay the company. Now, this is not all I have to support that. I'd also briefly lead you to his actual summary of findings at page 478 of the hard copy. That will just be pages down, that'll be under his paragraph 44.
Paragraph 44.
Yes, that's right, paragraph 44. And the second finding under that paragraph is the money was paid into the company at the direction of the defendant. So he says direction. And he says, and in furtherance of the agreement. And I think that what he means there, of the original agreement. And now, let me, before I take you to something which I think is very interesting, in the record where he actually talks about what he's going to do. He has a conversation with counsel. But I'll take you to that first. Bear with me, I'm sorry. Yes, this is page 365 of volume 1 of the hard copy. In the electronic bundle, it is MS 372.
Yes.
Lines 13 to 19. Now, this is a little conversation that he had with counsel after the testimony of Mr. Jerry.
Yes.
I know my lords would have seen I've placed a great deal of emphasis on that testimony. And it is in that testimony that Mr. Nure says on very many occasions that the agreement was always to pay the company, and that there was never any discussion about paying to the company because it was always understood.
So putting this in context, Mr. Rajkumar, here we are, we're at the end of the second day of the hearing in April 2011. There's a prospect of an adjournment, in fact, for almost a year, and the judge is saying, now look, even at this late stage, is there a possibility of settlement here?
Right.
That's the context, isn't it?
That's the context. That is the context. And let's see let's see how he was influenced by what he had just heard from Mr. Nerys. And at line, let's say the third paragraph, he says, I don't know if I'm thinking about it in a different way. Oh, sorry, let me start from before that. Let me start from line 10. So the bottom line, as it is now, appears to be that $1 million was paid to the company. I don't know that there is still any dispute in relation to that, and by extension, money was not paid to the defendants. And the agreement sets out a position. So he's identifying that the written agreement says something completely different. I don't know if I'm thinking about it in a different way. I'll say no more than that. But that seems to me to be suggesting, all the evidence is not in, but it seems to be suggesting that perhaps a court will have to look to see what was the intention of the parties and so on. Now he's talking about the intention of the parties in the formation of the agreement, that's my submission. Gathered from, and the court is entitled to look at, all the documents which surround it. And the court will no doubt look primarily at the agreement. But it is also entitled to look at communications between the parties shortly after and so on, such as are reflected in these letters. So I think that's an interesting and an important insight into what the judge eventually did. And I say that he accepted the testimony of Mr. Nerys, that the agreement was always to pay the company. And what he is saying here is that he is prepared by an exercise of what in his mind was construction to rewrite the original agreement. So he did not see it as rectification, but that's what he did. Now, in further support of my proposition, I know that I have made heavy weather of the fact in my written case that there is no mention of certain contractual language that one would expect to see in a judgment that deals with breach of contract. So you're not going to find the word consideration anywhere. You're not going to find the word variation. You're not going to find the word waiver. And you're not going to find what I would say, it's not spelled out what the juridical basis of the High Court's decision was. So I think that there's actually a reason for that. I don't think that the judge was unfamiliar with those concepts. I think that he very, very much there's no criticism to be made of him in that way. I think he did not use those terms because he found that the agreement always was to pay the company. So that's my certainty about that. Now, of course, all of this is premised on his acceptance. So I say that it's premised on his acceptance, not that there was a direction. He didn't disbelieve that there was a direction. He did find that there was a direction, and that accorded with the premise that the agreement was always to pay the company.
But does it matter? I mean, if there was a direction, one might analyze that in a number of ways. One might say, it had always been the agreement. I see the point that you make about it. One might say that there was a variation. Or one might say it doesn't matter whether there was an agreement, whether by way of a variation or original agreement, because if you direct somebody to pay a debt to someone else, and it's actually done, you don't need an agreement. All that's happened is that somebody's paid some money on the consensual basis that it's to discharge the debt of the creditor. I mean, it wouldn't be an agreement in the sense that you could enforce it, or it wouldn't necessarily be an agreement in the sense that you could enforce it before the payment had happened. But once somebody says, pay him and you pay, that's the end of it.
I think, again, that general proposition, I have to give the same answer I gave before. I think that one can't quarrel with that general proposition. It makes a very big difference who the party is that you are directing the money to be paid to. I think that if I am correct that direction wasn't the primary finding, one has to sort of look at carefully at the party to whom this purported direction was, who ended up being paid, and who ended up being paid. And again, I know that you're going to tell me I'm speaking the facts now. The party that was paid was a company that was about to be majority owned by the person who was making the payment. And that
makes it a lot more plausible to suppose that the money was going to end up in that company's pocket.
Well,
I mean, the identity of the payee is maybe relevant to the intrinsic plausibility of a factual suggestion that there was a direction to pay it, but it's perfectly plausible in this case. And anyway, both courts below have agreed that there was a direction.
I don't think that it's, well, in the cases, let me probably leap into some of the familiar cases where there has been a scenario where a party has agreed to settle for less than what was written down. Now we haven't even mentioned yet, of course, I think that there's something that has been important to the Supreme Court over the last few years, and that is the primacy of the language of the written instrument. And I know my Lord Sumption, Lord Toulson have given extra speeches on the matter. but the sorry, I kind of lost my trend there. Oh yes, the cases. In the cases where there has been this agreement, or purported agreement to take less than what I'm owed, in accordance with the written contract, there has always been evidence as to why did that happen. So that in Williams and Ruffy Brothers, for example, there was not any real dispute as to the facts. One party said, I will require £10,300 extra in order to complete work that I contracted to do, the very same work. And that was agreed. That was a discussion that was had. And the issue there, of course, was the consideration for that. There's always some material that the court can chew upon to determine, first of all, the reasonableness of the contention, and that it could be the fact situation can be analyzed in terms of consideration or waiver or something else. But here we've had no explanation whatsoever as to why a direction, which is hotly contested, why would it have been given on the occasions that Mr. Nerez eventually said that they were
I think
given?
the suggestion is that the company was in a ropey financial condition and needed the money.
Well, then why, very simple answer to that. Give the money to the appellant as agreed, and he will put it into the company as a loan.
Well,
But again, you say that's an answer, but where's the evidence of that? And there's absolutely no evidence that there was any financial bind that occurred on October 13th, 14th, 15th, or 16th. There's two occasions in that time period, especially right upon signing the agreement, that Mr. Nerez contended that the direction was given. So it's...
Can you speak up a bit?
It's quite unreasonable.
could you just raise your voice a little, please?
I did. I'll just take a sip if you don't mind.
Yes, by all means, by all means.
Mr. Rajkumar, the witness statement of Mr. Baptiste says 2 points, that the whole purpose of the transaction was to inject finance into the company.
Yes. Well, the few points I'll raise to that is that, and I know my lords do not need me to give a lecture on contractual interpretation or anything like that. Anything that was discussed before the agreement was signed is simply discussions. That, if there is such a line in Mr. Baptiste's witness statement, it's careless language, perhaps, but it's not fatal or even an injurious blow.
Well, following up what Lord Lloyd Jones has put to you, could we go to page 103, if that's convenient to you?
Certainly, we can do that now.
This is the paragraph 26 of Mr. Baptiste's witness statement. Your client is talking in paragraph 26 about a meeting in October, possibly between the 13th and the 15th of October. And in 26, your client says that Mr. Nerez made the following announcements: that he bought the company, that he agreed to invest $1 million Trinidad into the company. I mean, it couldn't be clearer, could it? That your client was accepting, when this witness statement was signed on the 2nd of December 2008, that the $1 million would agreed to be paid to the company.
All that tells me is that this is a report of what Mr. Nerez announced, but I don't know. And again, let's put ourselves in the position of just normal people. I mean, this is not a meeting of lawyers at that meeting, although I would indicate that Mr. John Jeremy, who is the respondent's lawyer, was at that meeting. And he said nothing about the written agreement being altered in any way. So these persons who sat here.
But if you bring together the 2 points that have been made to you by my Lord Jones, and my Lord Wilson, it comes to this, does it not? Your client was well aware of the parlous condition of the company and of the need for the injection of funds. Here he records in paragraph 26 what was announced by Mr. Nares without contradiction or challenge. Does that not give the plainest evidential foundation for the finding that has been made that there was a direction that the money be paid into the company?
No. There are a few things in there. One is, I know it's being said that the company was in a parlous condition. My lords, there is no evidence whatsoever that this company was in any sort of difficulty. The evidence is that the parties wanted the company to make more money.
Well, leave aside the question of it being in a parlous condition. As my Lord Jones has pointed out, it was originally conceived that this was to be an injection of funds into the company. Isn't that right?
Absolutely not. All that, what matters, as I would quote my Lord Sumption.
There's a similar statement in paragraph 8, Mr. Rajkumar.
Paragraph 8. Let me take a look at paragraph 8. But before I go to paragraph 26, I say again, if we sit in a meeting and somebody says that I agreed to invest $1 million into the company, you record it as an honest person, you put it in your witness statement. That's what he said. He didn't realize at that point that the man was serious. He really is going to pay the company and not me. But there's another point as well. The other point as well is that from the very get-go, there was an understanding by Mr. Baptiste, and it's in the appellant, and it's in his pleadings, that he thought the agreement was not just that you pay me $1 million, but that there are other measures that need to be taken in order to complete this agreement, measures to pay down debts and to deal with and to reduce the mortgages and to have a strategic business plan going forward. And that is what he pleaded to, and that was his subjective understanding.
Where does he say that, Mr. Rajkumar?
He says
in his witness statement.
He says
it's very different from what appears at paragraph 8.
Can I take you to his
paragraph 26?
It's in his defense.
Just address what he says in paragraph 8. Because I think that is very relevant. That's,
so that is the final point about the paragraph 26. I might be making the same point.
But just deal with paragraph 8 first, if you be so good.
Paragraph 8, Ambassador Nares arrived at the meeting.
Yes.
At approximately 3:35 p.m. And after some formalities, discussed the history and future objectives of the company. I then presented him with a copy of the company financials for the years 2001 and 2002, along with the current cash flows. We also discussed the company's indebtedness, its structure, and other pertinent company details. Included in discussions with Ambassador Nares was a proposal for the injection of $1 million into the company in an effort to enable the company to achieve its medium to long-term objectives. So this is referring to a meeting on the 17th of September 2003.
And this is the beginning of the scheme, isn't it?
That's the beginning.
Yes. So basically, the whole project originated in a proposal to inject $1 million into the company for a transfer of a shareholding interest. That's the proposal that they were discussing subsequently.
Well, but it's merely pre-contract negotiations. It certainly did not.
But it identifies what they were talking about. And we got onto this subject because of your suggestion that there was no evidence that made it plausible that they would wish to pay the money to the company. Here is the evidence out of your client's own mouth.
Do we take, I ask rhetorically, do we take evidence of pre-contract discussions into account?
Depends what we're asking ourselves. We certainly don't do that for the purpose of construing the agreement. But we can certainly look at it for the purpose of looking at trying to decide what the object of the transaction was.
What I would say is that this is evidence that may have gone towards the notion in Mr. Neres's mind that that was what the agreement was. The primacy of the written word, as eventuated in the signed contract, must take precedence over what was in people's minds.
Mr. Rajkumar, I wonder whether you would be prepared to address us briefly on the document that we have behind tab 6, which is Issues of Law and Facts, signed by your client's previous attorney on the 23rd of May 2008. Have you got that to hand?
I have it here.
Let's not bother with the issues of law at the moment. Let's look at facts in dispute. And there were 4. First, whether the deed of conveyance by your client to the company of the property was a forgery, whether, if it was executed at all by your client, the execution was obtained by fraud, whether the company, plaintiff company, paid the sum of $1 million to the company, whether the parties agreed that the property at number 33 should be paid to Blue Book, and whether your client agreed to the registration of the deed of transfer which he had executed in favour of the company, referable to the property. Now, where's the issue of fact identified? You'd have thought it might come in between 2 and 3. If the plaintiff paid $1 million to 33rd Avenue Limited, was that a proper discharge of its obligation under the agreement, in the light of the fact that the agreement said that the payment should be to the vendors? Why haven't we got that issue identified almost 5 years after the relevant events?
Now, it may sound incredible that at that point, the appellant did not know that $1 million had been paid into the Sarima account. But he did not know. He did not know. He was not shown evidence of that until the trial had begun. And there's a reason for that, which I have, but first of all, he does say that under cross-examination, but also that account in ARIMA was controlled entirely by the respondent. There was no way that he could have known what was happening in that account.
Now, Mr. Rajkumar, you're right to say that in his cross-examination he denied having known that the money was paid to the company. But of course, unfortunately for you, his evidence wasn't accepted. And the evidence of Mr. and Mrs. Neres was accepted. And if you'd be prepared to go briefly to page 254 of the transcript, you might read a bit of examination in chief of Mrs. Neres.
Certainly. Where would you like me to read?
At the top, if you've got it. Claimant's attorney, and would you know, have you got that bit?
Yes.
And would you know if Mr. Andre Baptiste knew that these monies were being deposited into this Scotia Bank account, this $1 million? Yes, they would know. And you know if they approved of it? Yes, they would have approved of it. So, are you entitled to rely upon your client's answers in cross-examination in circumstances where he wasn't believed and the Nareses were?
I am entitled to rely on the contemporaneous documentary evidence that was produced by the respondent and to see whether that accords with this speculative statement by Mrs. Narese that, yeah, they would have known. My answer to that is, well, how would they have known? And then we look at the board minutes that we prepared from October, November, and December.
I wonder whether you are, because the problem is that this evidence was heard by the judge. And the judge accepted it. And our position as an appellate court is that we don't, certainly in circumstances like this, make fresh findings on the evidence of witnesses that we haven't seen. We consider the adequacy of the finding that's been made below, in this case affirmed by the Court of Appeal. There's no reason, is there, why the judge should not have preferred the Nareses version of what happened to your clients.
Well, I don't know if this court has ever had to deal with a fact situation.
Oh yes, we have occasionally.
Sorry, with the particular fact situation where the claimant in this case, the respondent, the agents, both averred that there was no direction. It's a very special sort of case, and that's what makes it different. That's what lowers why I say that I have surmounted that threshold, because the agents of the respondent themselves, they're the ones that I'm not saying are not to be believed. I am saying believe them. Believe them. Believe Mrs. Narese when she says, nobody ever gave me a direction. My husband never gave me a direction. Believe Mr. Narese when he says, it was never discussed. There was no need for a direction. The agreement always was to pay the company, and he says it over and over and over. I know my lords have read his testimony as well, and not only the things that go against me. I'm sure that the things that go for me have been studied.
Well, Mr. Rajkumar, he says two things, doesn't he? He says that there was a direction on two occasions, and he also says there was no need for it. Because it was always the intention.
Well, having said, he has said those things, and I have pointed it out. But having made this very important statement that there was no need for it, that's correct, there was no need for it because the agreement always was this thing, then one has to look at the plausibility, and I suppose this is the part where you might want to say, well, you will defer to a lower court or not, but I know that there are occasions in which you have not deferred to the lower courts for very good reason, and I say this is one of those cases. Look at the plausibility. If the agreement, as written on October the 13th, says pay me $1 million, why would you get a direction on October the 13th to don't pay me $1 million, pay what I say, pay themselves $1 million, pay a company that you are about to be the majority owner of? Why would I do that? My Lord Sumption and my Lord Kerr, you did talk about the difficulties. Let us even say there were difficulties, and I say that there was not. The question is that those difficulties, there has to be evidence that those difficulties arose on October the 13th, on October the 14th, or October the 15th. Because that's the evidence of Mr. Narese of when the direction was given. And it is not enough to even, if you even conclude or believe that the company was in difficulties at the beginning, in September, whenever this first discussions took place, then the written agreement would have encompassed those difficulties, and the written agreement would have taken account. And it says, pay me. So the question becomes, for there to be a direction, a variation, a waiver, or giving away of the entire agreed consideration, give me the evidence of what happened on October the 13th, 14th, 15th.
I think we probably have exhausted that particular point, haven't we?
We have, and I just make the further point to that. If there was, of course, a direction, Mr. John Jeremy, senior counsel, was sitting in a meeting of October the 16th, and you'd expect that he would say something, that there'd be something recorded in the minutes. And Mrs. Neves herself, if we are to believe her, and let's believe her, she said, if there was any direction, it would have been recorded in the minutes. So it's not just me making an assumption. So those are the reasons I say this is a very special case. Yes. I don't think, I'm not asking you to disbelieve the respondent, I'm asking you to believe them. And when we come and I say, my Lord Jones pointed out something very important, which is that Mr. Neves said two things. And I say the primary thing, yes, was that there was no need to. The agreement always was this thing. Was the judge entitled to rectify the contract? Was he entitled to do that? When the pleading of the claimant, the respondent, was the agreement contained all the terms agreed to. And again, believe them, don't believe me, don't believe my client. That's their position from the very start.
Yes.
And yes, you took me to statement of facts and issues, and you made me feel uncomfortable. But how uncomfortable?
That was not a desire.
But I say that there's a lot more discomfort to be had on the other side, when they are taken to their pleadings. Why did they not say the agreement was always to pay? So I know that the court has looked for confirmatory evidence, including the witness statement of the appellant, where he talks about investment as an instance of pre-contract negotiations.
Rajkumar, reading the transcript, it does appear that the first time that this point was taken was at the trial.
What point, my lord?
The first point at which the point was taken, that the payment had been made to the wrong party, was at the trial. It's not foreshadowed at all.
What I would remember, in my little chapter on the subsequent conduct of the parties, which I could take you to, it does give an explanation of what the appellant could reasonably have known at what time. And you will see there that the real issue appears to be, and I'm, again, reviewing that record in the same way that you are. I wasn't there at the High Court. It appears to be, was money even paid into the ARIMA account? That seemed to be what was overwhelming the thing. Now, I can't put it, I don't think that I understand that these are valid questions, but I want to remind the court that the burden of proof at the High Court lay upon the claimant, and I say they did not acquit themselves of that burden.
Mr. Baptiste I'm sorry, I didn't mean to interrupt you, I'm sorry. Mr. Baptiste would have been aware that the payment had not been made to him.
Very much so. And
no complaint was made.
I don't know if that is a proper characterization. Now, I can't explain what other lawyers have done and why they did it. Why they did not highlight that. But certainly, in the trial, it was the predominant issue.
These events occurred in 2003. By 2008, as we have seen, this point was not being taken. But by 20th April 2011, the first day of the hearing, it was being taken. We don't see, this is Lord Lloyd Jones's point, we don't see any evidence that it was taken prior to 20 April 2011, which is about 8 years after the relevant events.
Yes, I'm going to troll through, but not, of course, during my speaking time. And if I find anything to counter that point, if you'd allow me to.
That's very fair.
Well, now,
Where,
where are we now?
okay.
Mr. Rajkumar?
So where are we now? I've taken you to what I tried to convince you that the judge took my client by surprise by making a finding that the agreement was always to pay the company, and he never had a chance to deal with that. And that was manifestly unfair and a miscarriage of justice. I will take you briefly to the Court of Appeal decision and to see what they found. And then we would really see, were the findings really concurrent? Did they make findings on the same basis?
Yes?
So this would be volume 2 of the hard bundle, page 169, tab 6.
Sorry, which page did you say?
This would be, yes, page 169, which would be tab 6, volume 2 of the hard copy, and in the electronic, this would be MS 698.
Line?
Or we could also read it from the written case. I have it in the written case.
Line 15, you want 15 to 21.
Yeah.
We've got the Court of Appeal talking about an implied variation. And your point is, well, that is a different analysis from the analysis that it had always been intended that the money be paid to the company.
That is my point. Yeah. And I think it's important. It's an important point. The Court of Appeal thought that they were agreeing with the judge below, and I think that they really were not agreeing with the judge below.
Well, they were not. They were agreeing with him about the facts. They were taking the facts as read from his judgment. At the most, it might be said that they differed from him in the legal analysis. But it may be, for the reasons I suggested to you earlier, that the legal analysis doesn't matter if the fact is that a direction was made and it was complied with.
What I would say to that is the legal analysis. What I would say is that there is the fact, or what I say. Let me not use the word fact. If I'm correct that the Court of Appeal agreed with the High Court on the assumption that the High Court had found a variation, and if I'm correct that the High Court did not primarily find a variation, he found, you know what I say about that, then it casts some doubt as to whether the Court of Appeal would have accepted what they thought was the factual basis for the decision that they thought the judge made. Now, the Court of Appeal was adamant that they were not entertaining the idea that the court below could have found that the agreement always was to be an investment in the company. And that's in the transcript, and I will have to take you to that.
Well, I think we've probably dealt with that, haven't we? It may be that there are other references to it in the transcript, but the essential point that you make about that is tolerably clear, isn't it?
Yes.
Right. Now let's move on.
So I'm going to concentrate on the facts, the evidence of direction from Mr. Nerez. Here, I've done a lot of quoting from it in the written case, and if you don't mind me reading through it emphatically.
Which page are we on and which volume?
So I will take you to volume 1, page 324, line 16.
Yes.
And there he says, at line 11, council says, so let's first deal with the transfer. There was to be a transfer of ownership of shares. Mr. Nevis says correct. From those two persons, yes, 50% plus one share, 50% plus one. And you went on to say, but it was to IML. The shares, yes, and IML will also inject the capital into 33rd Avenue. Yes. So he starts off saying that, and then let's look at page 349.
Can we just stick at 324 for a second, Mr. Rajkumar? The fifth line, have you got your predecessor, EP, saying, so is it correct to say? Or perhaps it's the fourth line, please forgive me. Your predecessor, EP, so is it correct to say? Have you got that?
Yes, I have it here.
That at that meeting, that first meeting, you told them, this is a question to Mr. Nares, I think, that you could inject $1 million, yes. So there, we've got your predecessor apparently putting a case that this was to be an injection of $1 million.
He's only referring to pre-contract discussions, and the loose language that was used then would, of course, have been clarified at the time of signing the agreement subsequently. So I can't put that very high at all. And it is very, very likely that they talked in that language using the word investment, using the word injection, using the word capital. These people not even knowing what they're really saying. But when it came down to it, and it's time to sign the agreement on October the 13th, what was put there on the instructions of Mr. Neves to his lawyer, Mr. Jeremy, and the language in that is very, very clear what that said.
Well, I understand, I think, Mr. Rajkumar, why you say that what matters is what you referred to as the primacy of the written word, what's in the agreement, and it's not consistent with the evidence. But if you and I are contemplating a transaction under which you're going to pay me $1 million, and we sign an agreement to that effect, is there anything inconsistent with that if at the very same time that we're doing it, or even before, I say, well, actually, I should be asking you to pay this money into the company? The point is, surely, that if I have an agreement which says that it's to be paid to me, I'd be entitled to change my mind, wouldn't I?
Well, from the times of great antiquity, we do have a certain policy. I think when I say we, I mean the English the Commonwealth contract world, that we militate against parole evidence being used to...
No, we're not varying the contract. The whole point is that the contract gives me control of where the money goes. But there's nothing inconsistent. What's inconsistent with my having control over where the money goes? What's inconsistent with that in my saying to you from the very beginning it ought to go into the company?
Well, excuse me, we pass a note. If you could bear with me.
Yes, of course.
An important note for the appellant. Okay. What I'm going to have to take you to, because I understand, Lord Hughes, I understand what you're saying.
Well, am I wrong?
What you're saying is...
What I'm asking you is whether there's anything inconsistent between, on the one hand, an agreement which gives me control about where the money goes, makes it payable to me, and on the other hand, at the same time, me saying from the very beginning or even before, actually, I should be asking you to pay the company. Now, what's inconsistent between those two things, please?
Persons have the autonomy to change their mind.
Exactly.
But when the person who is alleged to have changed his mind says, no, I did not change my mind, the burden is on the other side.
Yeah, it never happened, the change of mind. And that's why, on the claimant's case, the debt was discharged when he paid the company. But you see, well, there we are. I've asked the question. It's enough. You've had enough to deal with.
Mr. Rajkumar, I interrupted you. I said, let's look at something else on 324, when you were keen to move to another page. What was it?
I was keen to move to page 349,
Thank you.
line 21. So I suppose, well, here again, Mr. Neve says there was a condition of the agreement, and my lords, I think I've gotten that point, that is what was in Mr. Neve's mind, and I think what really I have to convince you is that it was not a condition of the agreement. I'll also take you very quickly to page 350, line 9. It says it again. Would you accept from her that no such decision is reflected in the meetings of the company? It says because it was a condition of the agreement. And then a little bit further down, line 19. It says again, it's a condition of the agreement. Then at page 356, line 12. Here's where he talks about direction for, I think, the first time. We had two such discussions. One was at the signing of the agreement, and one...
Sorry, page 356.
356, yes.
In the hard copy
Hard
number.
copy. From line 10.
Oh, I see. Okay, I got that. Thank you.
I think it was October the 16th. We had those discussions. It was held.
Yeah.
It was to be paid to 33rd Avenue. Council says, in which of these discussions did either Mr. Baptiste or Ms. McCarthy say, don't pay us, pay 33rd Avenue Limited? Mr. Neve says that was always the terms and conditions. Then the next page, 357, Mr. Neve says they discussed how the money, at line 12, they discussed how the money should be paid, and they did not say, don't pay me. The terms of the agreement was that we pay the money to 33rd Avenue. Council says no, referring, of course, to the fact that the written agreement says something else. It says it was never a consideration to pay them. It was never a consideration to pay them. Then I will take you to those are a few examples, but so a more detailed account, going back to page 356. And sir, you did not discuss at any time with Mr. Baptiste.
Sorry, you're reading from page
356.
356?
Just try to keep your voice up, Mr. Rajkumar.
My apologies. Yes, so from the very top, Council says, and sir, you did not discuss...
Sorry, you're at 356. Where on 356?
The second line.
Thank you.
Second line of page 356. And sir, you did not discuss at any time with Mr. Baptiste or Ms. McCarthy. You listened to me carefully. To whom should the $1 million be paid other than as you had directed Mr. Jeremy? Apart from what you had directed Mr. Jeremy to say, in other words, pay the people. You had had no other discussions with those two people about how, and Mr. Neve says that is not correct. Mr. Prescott says, well, tell me when was this other discussion then? There was a discussion which led to an agreement which said pay the vendors. Tell me of another discussion where they said to pay the vendors. And then he says the things that I already took you through. And he concludes by saying, Mr. Prescott ends up saying to him, sir, my question is, was there an occasion when either Mr. Baptiste or Ms. McCarthy said to you, don't pay us, pay 33rd Avenue? Mr. Neve says it was never intended for them to be paid. Mr. Prescott says, was it ever discussed? And he says, no. And in case that didn't go to my question, I will ask my question again. Was it ever discussed between you and Mr. Baptiste and Ms. McCarthy, or one of them, that the money should not be paid to the vendors as appears in the agreement, but paid in another place? And he says, can I ask for some clarification? Yes. You are saying it was never discussed that I, with Mr. Baptiste, Ms. McCarthy, and myself, that I not pay the money. So I prefer to ask a question. Okay, let me try clarity then. First question, does the written agreement reflect your instructions to Mr. Jeremy? And this is important. Mr. Neves says, that was my understanding at the time. If his understanding at the time of signing the agreement was that the written agreement reflected his instructions, and his instructions were to pay the appellant, then why are we looking at all of this evidence from what went before?
Yeah, but his understanding was that they would be paid to the company.
Yeah.
That's what he's just said. It wasn't his understanding that it would be paid to the appellant.
I interpret his saying that that was my understanding at the time as meaning that the written agreement reflected his instructions to Mr. Jeremy. But of course, it could mean either. Do you accept? Do you now? Let's see if it's clarified.
Well, I don't know that we're going to go any further with this particular point, Mr. Rajkumar. I certainly won't cut you off on it, but
Sure.
I think you might move to your next point.
So my next point will be, what are the reasons that were given by both courts for saying that they found confirmation in the subsequent conduct of the parties that, well, according to the Court of Appeal, that a direction was given, according to the High Court, that the agreement always was to pay the company? I will going to my written case, under page 24 of my written case, page 25 gives an analysis of the timeline. So this is analysis based upon the objective documentary evidence and things that I don't think are in dispute. On the 13th of October, the agreement was executed by all the parties. On the 16th of October, the first board meeting of the reconstituted board, chaired by Mrs. Neves, was held. And it's important what that minute says. Now, that minute is at volume 1, page 30. Page 30, volume 1 of the hard copy. 30.
Thank you.
30. And that would be MS 37 for...
Yes?
You would see here the item item 1.11, it was agreed that Ms. Gonzalez contact the manager of Scotiabank Arima regarding the setting up of a new bank account at Scotiabank Limited Arima in the name of 33rd Avenue Limited, and that $500,000 be deposited into that account. It was agreed that Scotiabank be advised that the signing authorities would be any two signatories as follows: Ms. Sharon McCarthy, Ms. Rani Lacan-Neves, and Ms. Michelle Gonzalez in Mrs. Neves' absence.
So do we note from 112 that your client's then cohabitant, Ms. McCarthy, was a signatory on the account which received $1 million?
This is the point I need to draw your
So
attention to.
when you say, you remind us that your client said in evidence that for 5 years he didn't know that the $1 million had been put into that account. He said that notwithstanding that his then cohabitant was a signatory on it.
What I'm taking you to this meeting, it's a very important minute, to show you that this is what was agreed at the meeting, that Ms. Sharon McCarthy would be a mandatory signatory on this very ARIMA account. And they'll be required to be 2 signatories, and the other signatory will be Mrs. Neres, or in her absence, Ms. Michelle Gonzalez. The next thing I'm going to tell you.
But that doesn't address, much less answer, my Lord's point.
Oh, here's the answer. The next thing I'm going to tell you is that Ms. Sharon McCarthy was never a signatory on that account.
But whether she was or whether she wasn't, she was. It was agreed at that meeting that she should be a signatory. And what my Lord is pointing out is the obvious incongruity of the case that your client ultimately made, that he was unaware of the payment into that account when his cohabitant was, in the course of this meeting, nominated as a signatory.
Oh, but I'm not saying that he was. I'm not saying that there was not this agreement and that the ARIMA account did not come up in a meeting and that he was not aware that there was this agreement. But what he's not aware of is that it ever went into, I'm not going to say ever, I'm saying at the material times. Let me restrict myself. At the material times, you would see from all the other board meetings that it was never recorded that $500,000 was deposited, but perhaps more importantly than that, it was never recorded that there was any other agreement that another $500,000 would be deposited, or that...
If he was aware, as surely he must have been, that, as recorded in paragraph 111, it was agreed that Mrs. Gonzalez contacted the manager and so on, in the name of him, and that $500,000 be deposited into the said account. He's bound to have been aware, surely, that that was going to take place.
Well, I'm sure that he, at that point, yes. But what was that $500,000 for? It is not in any way, anywhere said that this would be paid instead of to me. And I remind the board again of something I had mentioned about the subject, what the appellant had, in his mind, had thought the agreement was to be made, which is that there have to be other measures. This $500,000, to reduce debts and mortgages. What was this $500,000 for? It was not, I don't think, in anybody's mind, even though subsequently it was said to be in the Neves' minds. But it was never said that this is according to any directions to pay the appellant instead of himself. This was an additional thing to be accounted for, I would guess, as a loan or in some other way.
So the suggestion is then that as well as this £500,000 going into the ARIMA account, your client would get $1 million.
That's correct. And the $500,000, of course, would be returnable to the whoever put it in there from the profits of the company that is supposed to be growing and doing well.
Right.
There is no evidence now, and there is no. There is evidence. I would say that the mere fact that the minutes do not identify what this $500,000 is for is evidence of something. But it doesn't stand alone. We do know what discussions were had at that meeting, and that evidence is from the witness statement of Mrs. Vani Lacan-Neves. So if you want to know what was that $500,000 for, I think we could find it there.
Now, Mr. Rajkumar, I know you're coming on to Cherson's letter of the 14th January 2004, but this is really the moment to look at it, because it's on this same point about payments. And so if you've got page 140 to hand, and can we look at the last substantive paragraph? In the circumstances, our clients have instructed us to indicate to you their desire no longer to continue with the arrangement This will result in the refund to you of the monies already paid by you pursuant to the agreement, and this our clients intend to do within the next 3 months. So, what were the monies already paid by you pursuant to the agreement?
There is, at that point, there were checks, company expenses were being paid out of that ARIMA account in various amounts, but nothing to indicate that $1 million had gone into the account.
Did the agreement say anything about the payment of company expenses?
Again, the subjective view, as was pleaded by the appellant defendant, was that he thought that the agreement was what was written plus paying company expenses, paying down debts, paying mortgages.
Mr. Rajkumar, I'm just not convinced that is a satisfactory answer. Money is already paid by you pursuant to the agreement, capital A. You've said, let's look at the agreement. We know what the agreement said. It said nothing about expenses, so payments referable to expenses couldn't be what is here being referred to, could it?
It could. I think that it's unfair to insist that the written agreement is just is the only thing that's relevant when it comes to the appellant, but the written agreement doesn't have that relevance when it comes to the respondent. The appellant or the defendant had always contended that the written agreement was not the entire agreement of the parties. He had always contended that. That was his case. He relied on the fact that, well, he believed the thing wasn't even dated. There were errors even in the grammar. He said that it was to be finalized. Now, I'm not saying that he was correct to have that view, because my view is that the written agreement is the final thing, and that if you make the error of thinking that there are other things that are to be incorporated into the agreement, well, you have to put that in writing too. That's my view. That's a contract lawyer's view. But that was his subjective view. That is what is being referred to as pursuant to the agreement. But also, can we not, at this level, put the Cherson's letter at the height that it is put at the Court of Appeal and at the High Court? It has been viewed as a frank admission of receipt of $1 million instead in accordance with the direction. That is how it's been read. It cannot be read that way. And clearly, there would be no payment. Now, I'll take you to...
Do you accept that you have to establish that it's inconceivable that it could be read in that way?
Inconceivable?
Yes. That there is simply no basis on which the trial judge or the Court of Appeal could have interpreted this letter in the way that they did.
I think it is inconceivable because it has to be viewed in the light of the timeline. What could the letter have been talking about on January the 14th?
When it talks about a refund of monies paid pursuant to the agreement, you are saying that it meant what? Other money beyond the £1 million, which had somehow or other been injected into the company by the Neraces, is that it?
That is correct. Money was paid out of that account, and that would...
you would describe that as pursuant to the agreement, would you?
I would, because there is no reason why the Neraces, the respondent, would be writing checks for company expenses unless there had been some agreement.
Well, they're company checks, aren't they? Anyway, all right.
But this is
Checks
pursuant to the agreement.
Right.
Well, we're looking at the word "the" now. And
No, but it's a very simple proposition.
it's
Your client's attorneys were writing in reference to monies paid pursuant to the agreement. That will obviously take the reader of that letter to the agreement. And the agreement provides for the payment of $1 million. It doesn't provide for incidental payments. It doesn't provide for what you describe as contributions towards the company accounts. It provides for $1 million. So for my part, I have to say frankly, I find it very difficult to understand how you can make the claim that it's inconceivable that the trial judge and the Court of Appeal could have treated this letter in the manner that they did. But there it is. Perhaps we've exhausted that subject.
I'm going to try to still convince you. I did mention that we have to look at it in the context of the timeline.
Right.
So if I can return to the timeline, so I've taken you to the point of October the 16th, when there is an agreement to pay $500,000 into the ARIMA account. Part of that agreement is that the first defendant would be a signatory, and I will show you that she never was a signatory, or you can accept that on the evidence that I'll bring you to. So there was no aspect of the defendant or his cohabitant having any control over that ARIMA account at all.
Yes.
Yes. So Mrs. Nevis does not talk at all about either in the minutes or in the witness statement about what that $500,000 was for. I've made that point. I'll move on. I've made the point that the appellant had contended at all times that the agreement was not to be given effect unless a strategic business plan and measures for reducing or liquidating a mortgage or debts or charges affecting the Sinclair property were agreed. So subsequent to that, there has been no recording that that $500,000 was paid or was deposited, or that there was any further $500,000. Another important aspect of not only this minute, but all the other minutes, is that there is no instance in those minutes saying what we would expect to be said, which is, we have paid $1 million to somebody, and we demand that you, or request that you now transfer your shares. It never came up in any board meeting. If $1 million was paid, if it were drawn to the attention of the appellant, you would expect that it would be memorialized in the contemporaneous documents, which were produced by the respondent, and you would expect that you would see that request in there, and it never happened. On October the 23rd, the appellant signed a deed of conveyance. That was a precondition of the written agreement. So at this point, no money has been paid into the account. There has been this agreement for $500,000, but nothing more. And the appellant set about fulfilling his side of the bargain, which was to do the first thing that was required, the first step, signing the conveyance of his property, the Sinclair Avenue property, to the company. And what is the significance of that? This was thought by the Court of Appeal to be evidenced by conduct that the appellant had accepted the purported variation. But at this point, October the 23rd, there had been no breach of contract by the respondent, no notification of intended breach. The agreement to pay $500,000 into the ARIMA account was entirely consistent with the appellant's understanding that in addition to being paid the agreed consideration, measures were to be taken for reducing or liquidating a mortgage, etc. Okay. That takes us to October 23rd. The other evidence as to, because it's important, what was that $500,000 for, or maybe what was the appellant entitled to believe that that $500,000 was for, because I do maintain he certainly did not think that this $500,000 was to be a replacement to paying him. At the witness statement, and this would be at MS 29, or in the hard copy, volume 1, page 22, paragraph 10,
Sorry, what page did you give for hard copy?
Hard copy, page 22, paragraph.
Yes?
And at that paragraph 10, it is said, that's at the very top.
Yes.
At that meeting, we also discussed the arrangement by which IML will pay $1 million to Ms. McCarthy and Mr. Baptiste. Now, this is not my evidence. This is evidence from the respondent. At that meeting, we also discussed the arrangement by which IML will pay $1 million to Ms. McCarthy and Mr. Baptiste. And they would in turn transfer 50% plus one share to the company, of the company to IML. It didn't say we also discussed the arrangement by which IML will pay $1 million to the company. It says $1 million to Ms. McCarthy and Mr. Baptiste. That is in accordance with the agreement, and that is what was in her mind as well. And this is the respondent. And this is in October. This is in reference to the October 16th meeting. The agreement was signed on October the 13th. We also discussed that the property would be transferred into the company's name. Right? That is the October the 23rd conveyance. We also discussed that going forward, the company would need to have a strategic plan or business plan. So when the appellant had in his mind that part of the agreement was for reducing or liquidating a mortgage or debts or charges affecting the St. Clair property, I submit that it was not only in his mind, that those were discussions that were being held, whether they had contractual effect or not. I don't know if it's important, but it does explain why the appellant did not and could not believe that this $500,000 that was to be deposited into the VMO account could be a payment to him. According to Mrs. Neres, we also discussed that going forward, the company would need to have a strategic plan or a business plan. We also had discussions about the company's cash flow, that more money was needed to grow the business and to purchase more inventory. Again, very much in accordance with the appellant's understanding, if you don't want to believe that his understanding was that was part of the agreement, but it's certainly part of his understanding of what that $500,000 was for. This will be part of the strategic plan for the company, which will be decided on in the future. Words that accord, dovetail almost perfectly with what the appellant says himself about a strategic plan. The appellant in his pleadings said that the agreement was not to be given effect unless a strategic business plan and measures for reducing or liquidating a mortgage or debts or charges were agreed. So they were talking the same language. The respondent, the appellant, were talking the same language as at this meeting at which $500,000 was agreed to be put into an account, and an account in which the controlling signature was to be.
Yes, well, we've got that point.
Thank you. So I move on. That there's even more evidence about this, what this $500,000 was to be for, and not that it was to be a payment to, instead of paying the appellant. The other evidence is, I will take you to, the appellant's own witness statement, paragraph 28 of his witness statement. Witness statement begins at page 99. 28 of this witness statement. It reads, notwithstanding the tensions that pervaded the atmosphere, the first defendant was asked by, that's Ms. McCarthy, was asked by Ambassador Neves for details on the business of the company, which he reluctantly gave. Ambassador Neves then said he would set up an account at Scotiabank Arima for the company, and that he would take care of the inventory purchases in the sum of $50,000. It says $500,000 there, but I think it really means $50,000 for the upcoming Christmas season. And it goes on, he asked the first defendant to submit details of the purchases and urgent outstanding bills and to report all matters pertinent to the business to Mrs. Neves on a daily basis. He also suggested that both the first defendant and Mrs. Neves. So again, it's not only that the appellant is saying that he had that discussion, but Mrs. Neves is talking about virtually the same thing. Another aspect of the witness statement of Mrs. Neves is that, I know my lords asked me before that one would expect to see certain things in documents that are signed by the appellant. Very fair point. One would also, but I want to say that what is good for the goose is good for the gander. One would expect to see certain things in the witness statement about Mrs. Neves. She did not mention that $500,000. He did not say that it was agreed to replace paying the agreed consideration to the appellant. So it's not in the witness statement, it's not in any minutes. And I say that, isn't it a necessary inference or reasonable inference at the lowest, that would be something that is said in her witness statement?
I thought it was being said in paragraph 15 on page 23.
Page 23.
If you've got that, after the deed was executed, $1 million was paid by IML to the company in accordance with directions from Mr. Baptiste. And the first one, 29 October, $500,000. So she's clearly saying the $500,000 is part of the $1 million, which was payable pursuant to the agreement.
I don't agree with that respectfully.
Okay.
Because I am looking at what does she say about the board meeting. Now, what happened subsequent to the board meeting? The board meeting was on October the 16th. And yes, she says that these checks, she's correct, these checks were written on October the 29th, October the 30th, and November the 6th. But that link that my Lord is drawing between that is not the same as saying that at the meeting we agreed that this $500,000 would be paid instead of paying the appellant. It's not at all. I say that the link between that $500,000, which is not discussed in the context of the October 16th meeting at all in this witness statement, the only link I could find is when she talks about company's cash flow purchasing and purchasing inventory.
But the agreement says $1 million, the agreement dated 13 October says $1 million will be payable. And it'll be payable after the transfer of the property.
Sorry,
the property gets transferred, doesn't it, on the 23rd of October. And within a fortnight of the 23rd of October, $1 million is paid in 500, 100, and 400,000. It's a bit of a coincidence if that's not the $1 million referred to in the agreement, isn't it, Mr. Rajkumar?
Let me. It is certainly no coincidence at all, and I'm not saying that it's a coincidence that $1 million was paid into the REMA account subsequent to the execution of the October 23rd conveyance. It's not a coincidence at all. But what I was dealing with was that $500,000, which it has been agreed to be paid at the meeting. Who said that that would be part of this agreed consideration for the agreement? Who said that? Nobody said it. There's no record of anybody saying that's what it's for. It's no coincidence that this money was paid. And the trial judge himself said, well, without more, why else would it have been paid? But I think that's not enough. It's not good enough. It's not good enough. It's very, you say convenient, or maybe I misquoted. You said coincidence. But I say it's very convenient that the $1 million was paid to themselves, to a company that I'm going to control. That is what is very convenient. And I'm saying very likely. There are two possibilities: that it was paid under a mistake, that is what the agreement said to do, or it was paid saying, look, we don't really care what the agreement said. We will pay it to ourselves, and maybe we'll get a court to say, well, wow, $1 million was parted with. So it must have been that the agreement said to pay it there. But I think it's a very material consideration that the $1 million was not parted with. It was paid to themselves. It's another material consideration that there's no evidence that was adduced by the respondent who were in control of that account up until, I think, 2008, 2009. That there was no evidence from them of what money was paid out of the account. That evidence was provided on behalf of the appellant, that $414,000 was paid out of that account. And that's the money I say, okay, we can accept that money was paid for companies' expenses out of that account. So, no, I do not equate or in any way draw anything. I think that paragraph 15 supports me. This is what I say about paragraph 15.
Very well, thank you.
Okay, so we move now to...
Yes.
We move now to... I will take you to volume 1, page 289, line 4. I'm just going to read a little bit from the page before for context. The attorney says, you decided you would become involved in the reorganization and enhancement. None of those appear in the agreement. So the point that Mr. Prescott was making at the High Court is that there were many things that were being done that were not in accordance with the agreement. And that's what he was getting at. And is it that the agreement really was more than was just written? Mrs. Neves said, no. Mr. Prescott says, so I'm asking you, by what authority did you take those steps? Why were you reorganizing? Why were you buying stock? And Mrs. Neves says the obvious thing. She says, okay, it's just that I don't understand by whose authority, because Mr. Neves had indicated those were discussions that were held with the other parties, and that was my understanding, that was part of the agreement, in terms of not the formal specific agreement, but that was the intention, in terms of investment in the business. Now, I feel I should pause and let that sink in a little bit.
No, I think
but I will not pause. I will move on. But clearly, my lords get my point, that both parties seem to have been in accord that the respondent will be investing in the business as well as paying according to the written agreement. She did acknowledge that there's the formal agreement, and then there would be this other thing where there will be enhancement of the business, reorganization, all that. Okay. So now we come to October the 29th, and where my Lord Wilson had directed me, where those checks were paid into the Sarima account. And a point I'll make there is that the Court of Appeal, in its written decision, I guess I'll take you to it very, very quickly, or you could take my word for it. But let me take a look at it. Volume 1, page 473, paragraph 16. This is of the High Court decision, and the judge makes maybe this is a typographical error. It says the checks were paid, or
Which
maybe it's
paragraph?
more than that. Paragraph 16 of the High Court decision, that's page 473 of Volume 1. And he records that the checks were paid on 3rd of October 2003, the 6th of November 2003, and that the conveyance was dated the 23rd of October 2003. Now that's probably not just a typo. I think that he got it wrong. And if he did, it's a serious thing, because the checks were, of course, paid on the 30th of October, the 29th of October, and the 6th of November.
So 6th of November is right, and the other one...
That's right.
Yep.
And it becomes important because he was looking at, well, why would anybody sign the 23rd October conveyance when knowing that the check had been paid on the 3rd of October? Well, of course, I also say that it was, I've said it 100 times, that it was never drawn to the attention of the appellant, even after the 29th of October, or whatever, November, that any such thing had been done. It's not recorded anywhere. It's not recorded in the minutes. And the most that Mrs. Nevis did say about it is that they would have known. And I know one of my lords had taken me to that and grilled me on it. But all she could say was, yeah, they would have known. They should have known. It's not enough. Because the minutes were controlled by the respondent. They wrote everything that had to be written in those minutes. Okay. All right. So that's November the 6th. I will go now to... and another little point I'll raise is that... and when we look further at Mrs. Nevis's testimony, we'll see that she actually maintains that those checks that she signed to go into that REMA account were not done by her in accordance with anybody's direction. She could not explain why she did that. She said that, and I'll take you to that in a little while. On November the 10th of 2003 was the second board meeting of the company, and we could look at it briefly. This is page 36 and 37.
I'm sorry, page?
36, 37, 36, 37.
Can you help me with the fragment at page 38? There seems to be a fragment of another meeting at 38. I don't, if you can assist.
Oh no, ignore. Can you ignore page 38? I don't know what.
Right. Well, don't worry about that.
Yes, that's
page
not
36.
Yeah, 36 and 37. I think it's complete.
Yes.
And just the observation I'll make about that is we will see that this is November the 10th. The checks were paid, as we just saw, up to early November, into their REMA account. But there's no mention here at all of that ever happening. There is talk about the company would be refinanced, and there's talk about the stock. It was advised that stock is usually purchased for 6 months period. Everything indicates that this money that was agreed to be paid in the last board meeting would be for these purposes, and there's no mention that this 500,000, by the way, it was paid, and by the way, we paid another 500,000 in it as well. No mention at all. So they say that it was agreed that the company, that is at paragraph 116, paragraph 16 onwards, so it was agreed that the company would be refinanced, particularly its loans, and it would be financially wise to separate both properties for better financial arrangements. The meeting agreed to convey the 33rd Avenue property into a wholly owned subsidiary named Blue Book Company. This would replace the deed dated October 23rd, since it would not make good business sense, etc. And so at that point, the October the 23rd deed was scrapped. It was agreed that that thing you signed on October 23rd, you don't have to worry about it. Remember, it was not registered or anything. It was merely executed. And it is agreed we're not going to bother with that. We'll ask you to instead sign a conveyance of the 33rd Avenue Limited property to a wholly owned subsidiary called Blue Book. And in pursuit of that agreement, something happened on the 27th of November 2003. And that is at his witness statement at paragraph 36, which is page 106 of the record.
We've looked at this already, haven't we?
This deals with the Blue Book conveyance. I don't think that we've looked at it yet.
All right. Which paragraph then?
Paragraph
Why
36.
is this business about the proposal that the property should go to a subsidiary and then Blue Book, and it being discovered that Blue Book wasn't formally a subsidiary of the company at the relevant time? Why is all that relevant to the issue that you put before us?
It goes towards why, one of the reasons, a major reason why the appellant decided, well, nothing has been done. Nobody's paid me any money. I didn't sign the Blue Book conveyance. It was agreed that the October 23rd conveyance be scrapped. So,
Very well, Mr. Rajkumar. I mean, I'm very conscious of the fact you've got less than a quarter of an hour left, and so I just wanted to steer you to your most important remaining points.
The Blue Book transaction is important because it had the hint of fraud. That's why it scared the living daylights out of the appellant, and he thought he could not trust him. There's something I want to also let you, in the volume 3 of the injunction proceedings, is the only copy of that Blue Book conveyance. And it is at page 178 of volume 3, MS page number 887. Oh, sorry, I'm taking you to the wrong thing. Please ignore me. It is page 50, page 50, 51 and 52 of volume 3, MS page number 761. And I think it may mean something that this Blue Book conveyance was not annexed to the respondent's evidence at all. They did not annex it. Pat Simon, who did prepared it, did not annex it, nor did Mrs. Neres or anybody else. And this conveyance at page 51, you will see it also says, under now this deed witnesseth, it says, in pursuance of the said agreement and in consideration of the sum of $1,500,000 paid by the purchaser to the vendor, and it goes on to say that paid by the purchaser, that would be Blue Book, to the vendor, who is the appellant, then there will be this conveyance. Now, that is not in accordance with any agreement by anybody. And it does support the allegation that something was very wrong with respect to this Blue Book conveyance. Because somebody could have held up this conveyance after, if it indeed was signed, and said, what do you mean wholly owned subsidiary? We paid you $1.5 million. Your signature acknowledges it. So for these reasons, the appellant, of course, was justifiably just wanted to get out of a relationship with people he could not trust. And he did not know that any money had been paid anywhere, and that money was being represented in their minds as being a payment to him. Just didn't know. And that is supported too by the witness statement of Mr. Neres, which is at volume 1, page 68, paragraph 14. Where Mr. Neres says, in the run-up to the Christmas of 2003, Andre Baptiste contacted me via telephone and indicated that he had changed his mind about the business deal. He indicated that the arrangement of transferring the property at 33 Sinclair Avenue, Sinclair, into Blue Book Company Limited, which was supposed to be a wholly owned subsidiary of the company, was confusing to him. It was, however, obvious to me at that time that he did not want to go through with the deal. So that was the motivation, a primary motivation. Now, it so happens that in the time of the Chairman's letter 2014, Mr. Baptiste was entitled. If he had known that this money had been paid to the company instead of to him, he was entitled to have said, "You breached the contract. You breached the contract, and I want my damages," or he would have been able to elect what he did at that point. But there has been this complaint about the Chairman's letter that it said nothing about being paid. And I think I have illustrated to you that it said nothing about being paid. It was not an issue. He could not have known. There is no evidence that by January the 14th, anybody told him to be paid. Let's say that he is taken to have known that some money was put in an ARIMA account. How was he supposed to know it was exactly $1 million? How was he supposed to know that that was money to be paid, not for stock purchases and all the other things that were discussed at that meeting, but it was supposed to be paid instead of to him? He would have been very surprised to know that. But it couldn't possibly appear in the Chairman's letter. Couldn't appear. He didn't know about it. Wasn't his motivation for giving instructions regard to the Chairman's letter. His motivation was the Blue Book transaction. And I would say that I'd also direct you to because I think that I can't just say that the High Court got it wrong. Part of the difficulties that you pointed out to me is that the Court of Appeal seemed to have endorsed findings. But if you look at Volume 2, page 169, take you to...
Sorry, page?
Volume 2.
Yes.
Page 169.
Thank you.
Line 32. In which in the judgment of the Court of Appeal, it speaks about, and it's part of the evidence that they relied upon, the letter from the appellant's attorneys, that's the Chairman's letter, in which they confirmed the receipt of $1 million in accordance with the agreement. Chairman's letter says nothing like that. Never said, we received him. $1 million was not mentioned. There was no...
Yes.
I know you got... Sir? Yes, you got that point.
You have 7 minutes left, Mr. Rajkumar.
Yes.
So you might want to wind up.
Certainly. So the next thing that happened is that on the 9th of March, 2004, the respondent registered the deed. That was the response to the chairperson's letter, from being told, let's see how we can get out of this. It took 2 months and registered the 23rd of October deed. Now, that deed was registered without any recourse to the mortgagee. There was a mortgage on the property. Everybody acknowledges that. And the mortgages on the property, it was the lawyers for the respondent had written to Mrs. Nerez and pointed out that consent would be needed to do that. They did not obtain any consent from the mortgagee. They just went and registered it. I call it sharp practice, and I've seen it referred to, that sort of action is actually being described as illegal. It's an illegal action. If the deed were not what is known as a common law deed in Trinidad, if it were a registered title deed, it would have been arguably an illegal transaction to register it without the permission of the mortgagee. The mortgagee, of course, would have in turn had to verify that transaction with the mortgagor, Mr. Baptiste. That never happened. But that's what they did. Then they sent a letter on the 11th of March 2004, finally responding to the chairperson's letter of 2 months before. And that letter, chairperson's letter, let me tell you where that is.
142.
Sorry, not the chairperson's letter, the David Young letter. 142, thank you. Thank you, I'm very grateful. And in that letter, we are instructed, I'm reading just the first paragraph, we are instructed by our client, Investment Managers Limited, to reply to your letter on January the 14th as follows. 1, the subject agreement provides for the transfer of 50% plus 1 ordinary share. And the second paragraph is the important one. The conditions precedent to the share transfers have been satisfied. The sum of $1 million has been paid to your client. And then it says that the conveyance has been done. Now, that is a factually incorrect statement. The instructions that Mr. Young got to say that, he got from Mrs. Nerez, and that is in the witness statement of Mrs. Nerez, where she confirms that she gave him instructions, but she also said under cross-examination that nobody directed her that money was to be paid to the company. So there's a false premise in this letter, and the proceedings were started under this false premise. I know that you have pointed out to me that the response, the written pleadings, would not express that outrage. What are you talking about? But I say to see that in the context of the lack of sufficient pleadings from the respondent who had the burden of proof. So I say that I've got the point that my primary submission is that there was no directive. And I say there was no directive because Mr. Nerez, to whom the directive was allegedly given, I know he said two things. My Lord, Justice Lloyd Jones pointed out he said two things, but he primarily said there was no need for a directive. And in respect of that, therefore, I say that the courts were wrong. I also say when they looked for support for this directive in the subsequent conduct, they got that wrong as well. So I think I would, until I reply a little later, that would be my submissions for now, unless there are any questions.
We'll rise for a few minutes to see what happens. I'm very grateful to Mr. Raj Kumar for his comprehensive and tenacious presentation of the case, but we don't require to hear from you, Mr. Kangaloo. The board will take time to consider their judgment, and the court is now adjourned.